Who in the matter of our children?
Yes, Mr. Newton, Mr. Bennett, I'm sorry we've kept you waiting.
May it please you, my lords, I appear on behalf of the appellant mother, assisted by my learned junior, Miss Alison Hunt.
Yes.
And my friend, Mr. Jonathan Bennett, appears on behalf of the first respondent, the local authority.
Yes.
Before I commence on my submissions, I ought to draw to the attention of the court something I discovered only fairly late yesterday evening. And it relates to the fact that there was a welfare hearing in December,
Yes.
which resulted in a final order.
Well, that we knew. Could I just, before we
Yes.
Embark on any issues of substance, just say this, because we are live streamed
Yes.
at this hearing, and in any case, I would say this, that as this case involves matters concerning children, the normal order in this court will apply, namely that no report of the proceedings is to identify the children or their family.
Indeed.
Now, I know that consequent on that, we will all want to minimise the reference to individual names, and I'd like to suggest that we simply refer to the participants as being the mother, the father, the older child,
The oldest daughter.
the oldest daughter, the baby.
The child, yes. A friend and I have discussed this.
All right, you'd like to
and
call
we
her the
have-
child,
we-
that's fine. And in relation to the aunts, I'd like to do some stock taking about the aunts with you later, just to check that we have the aunts in order, but we'll refer to them by the initials
SH, SA and N.
SH, N, SA and N. That will be helpful. Now, there may from time to time be lapses. Any time that you start to read anything that has names in it, you'll surely read out a name. Please try not to do it, but it's not the end of the world. So we'll do the best that we can with that. And if anything I don't expect what was said that really shouldn't be said, well, then we have a means of pausing the live stream to make sure that it's corrected. So now, yes, the proceedings concluded.
Yes. In the previous cases where I have been involved in an appeal against fact-finding, of course, everyone was careful not to conclude the proceedings before the outcome of the appeal. And in this case, that hasn't happened. It was the result of the concluded hearing was that the children were returned to the parents under a 12-month supervision order. Of course, if we, at the end of this appeal, if our appeal were unsuccessful completely, then it wouldn't matter.
Yes.
If, on the other hand, our appeal were successful in one way or the other, and there are two possible ways it could be successful, of course. It could be that this court feels able not only to set aside the judgment, but also to replace the order that he made by its own order.
Well, you can reassure yourself on that issue, Mr. Newton. That's not a realistic outcome.
I will. Then there's the two alternatives. If we were to succeed and your lordships set aside the judgment and ordered a rehearing, then under these circumstances, what my learned friend and I have discussed, this court could set aside the existing final order and replace it with an interim order for a supervision order without limitation of time.
Well, I have to say that was exactly the thought process that occurred to me, and I'm glad that you've been able to discuss it. So the prior question, and this is all hypothetical because you have to succeed in your appeal first.
Yes.
Is the question of remittal for a rehearing, because let us suppose, for the moment, without prejudice to all of the arguments that we're going to listen to, that we felt that the judge's findings had to be set aside. Then, in the circumstances which have arisen, the question would then arise, as indeed it might arise in a criminal case, whether there should be a rehearing or not, and that would be something in which the local authority, the guardian, and
yes.
indeed your clients would have a view, and so we would need to have some submissions either at this hearing or shortly afterwards as to what would the right consequence be for not only the children but also the interest of justice generally, in terms of whether we should remit for a rehearing before a different judge. If so, what would the parameters of that rehearing be, given that you failed to achieve permission in relation to medical issues? And so the alternatives there would be that on the one hand there would be a rehearing which would take place without any nudge from this court and simply reach a conclusion, putting everybody through the whole process again to a greater or lesser extent.
Yes.
After still more time has passed, or that the proceedings simply came to an end on the basis that the local authority withdrew their proceedings or something of that sort, with no finding being made either way. And that is a matter upon which I would, if we got to that point, stress that we would have a completely open-minded sense of wanting the parties to address us on that rather than us to address them. Yes.
I'm grateful for those indications. Before I proceed then, I would just indicate that my client, the mother, intended to be here. She's coming. Her train was cancelled. And we're not quite certain precisely what time. I think Melanie Jr. thinks it will be about 11 o'clock, but so shortly. But you might find it difficult to find.
Well, thank you for explaining that. Yeah.
And if my junior hears by communication from the mother that she's here, then my junior may depart the court for that purpose. So,
thank you.
On that basis, then, my lord, I will commence my submissions.
Right, well, could I, just so that my note is complete at this point, do some factual matters, because we've obviously understood this, but so that I can trace the movements of there are 3 young children who are the subject of proceedings. Can we take the 2 elder ones who were, I think, originally taken to foster care and then went to an aunt and uncle?
That's right, isn't it? Straight to family.
Straight to family.
Yeah.
So I have a note that on the 29th of May, so some weeks after, that would make sense actually.
Yes.
So they went to a paternal aunt and uncle, I think it was.
Yes, that's
where they remained until when?
right.
August 2023.
23. They remained there until August 23.
At which point they returned.
They went to their father.
But living with mother.
But now?
No. So what? I wonder, can Ms. Hunt help us about this?
Yes, perhaps. The children were returned to their father's care under the interim care order, the mother and the eldest daughter were out of the property at that time, and the father was caring for the children alone, all three, in fact.
Right. And so what was the then effect of the conclusion of the proceedings in December?
By December, the mother had moved back into the property.
And where had she been?
At the maternal grandmother's with the eldest daughter.
But also at the maternal grandparents also was the youngest child.
So she had moved home with her siblings to her father's care. Effectively, the children moved back into the family home, and the mother and the eldest daughter moved into the maternal grandmother's home for that interim period of time.
Right. Would you mind doing us a note, please, because I don't want to take any more time on this, as to what the movements of the children and the parents were in which homes, and let us have that by the end of the day.
Yes, we don't, certainly, my lord.
Thank you.
Yes, with dates. Yes.
And also what the headline supervision requirements were and weren't.
Yes, I can certainly do that, my lord.
Thank you.
Lord, you'll understand that I've never been involved in the welfare aspects
No.
of the case. This, my lords, is an appeal against findings of fact made in care proceedings. The findings of fact made by the judge on the 26th of June last year were that the injuries suffered by the child, who was then aged 8 months, were inflicted in an episode of shaking on the 11th of May 2022 by one of the mother and the 5 interveners, the mother's mother, the maternal grandmother, MGM she might be referred to, the mother's oldest daughter, and the mother's 3 sisters, N, SA and SH.
Do you mind if we assemble them in age order?
In age order.
Age order, yes. SH is the eldest sister.
Yes, she is, that's right.
Who, I don't have her precise age, but she's slightly older than the mother, who was 38
Yes.
at present day. The mother comes next. N comes next at the age of 33, and SA comes last at the age of 31, and there are various other siblings who are not material to our narrative.
No, that's right. Yes. The learned judge's findings of fact then were that the mother and the 5 interveners, one of them had been responsible for the injuries and made lying accounts that M's injuries were caused by an accidental fall. He did not find that they had colluded.
Well, you say they've given lying accounts. Where does the judge find that?
It must follow from his judgment, I would have thought. It's clear that one of the criticisms that can be made of the judge and the judgment is that it is absent a number of a great deal of clarity in respect of findings. And with respect, your lordship is right. I mean, I've said that, but that is just, to some extent, guesswork.
I thought your whole point was that that's a finding which followed inevitably and which the judge didn't make.
Yes, well, that's
rather than
that is what we say. Yes, what I'm saying is that he, his lordship indicated that he hadn't made the finding was correct.
Yeah, but the other thing is that it's not clear what he didn't make a finding. But it's not clear what finding he didn't make, because I don't think we'd gain from the judgment, and your client or her family wouldn't gain an understanding of whether he accepted that this child fell over or not.
Yes, that is not entirely clear. All I can say is, of course, and it appears from the transcripts, that there was no suggestion made by the local authority that there was a fall followed by a shaking. The suggestions were always made that there was a lying account of a fall that didn't happen, and that there was an episode of shaking that did happen. But the judge absolutely did not clarify.
It doesn't matter whether the child, I mean, in a sense, in one way, from the local authority's point of view, it doesn't matter whether the child fell over or not. Children fall over all the time. And one reason why the family was able to give what the judge described as a relatively consistent, at one point, account of a fall is that the fall may have happened, but it didn't cause the injury. Yes. But the judgment doesn't
deal with
tell us.
Doesn't deal with that at all. No suggestion that by the judge that there was or wasn't a previous fall which might have assisted.
No, and even the judge was asked for innumerable clarifications, but those weren't any of the ones he was asked.
That's right.
Well, I mean, I'm not meaning to be unkind about this, in the sense that you'd have to take that if these are important points, as it seems to me they might be, they weren't ones that the judge was taxed with.
No.
As part of the clarification exercise.
That's right. Yes, that is right.
All right.
The mother's case, in short, is that the judge delivered a judgment so flawed that his conclusions are invalidated, and along with his, in what we would submit is an invalid assessment, a credibility assessment, are the points that your Lordship has just mentioned. In this case, as is stated in your Lordship's decision in granting permission, from the medical perspective, the medical evidence was not diagnostic. Both inflicted injury and accidental injury are therefore possible causes. And it's our submission that whatever the precise degree of likelihood from the medical perspective was of inflicted injury, it was undoubtedly incumbent on the judge to carry out a proper assessment of the lay evidence, taking into account any improbabilities of inflicted injury from the non-medical perspective. And the judge, in our submission, the main criticisms of his judgment and where he made his errors were of two fundamentally different types. One is in his veracity assessment, and the other is in respect of his failure to take into account the improbabilities of one kind or another of inflicted injury from the non-medical perspective. The judge, in his judgment, dealing first with the aspect of his judgment which we rely on as saying is flawed by his wholly unsatisfactory, not proper veracity assessment. He based his conclusions in that respect, as he says in paragraph 203 of his judgment, on the widely different accounts given on various occasions, for example, as demonstrated by the eldest daughter and the maternal grandmother, and other accounts given by the family members, which the judge concluded cast doubt on the veracity of some of the evidence. He carried out his credibility evaluation in paragraphs 180 to 203 of his judgment. His judgment starts in the core bundle, I'm sure you've got it, at page 95. He deals in turn with each family member, making points as he goes through in respect of each family member, which he relies on as creating discrepancies, which he, at the end, says cast doubt on their veracity. I should say he did not, however, give any evaluation of SH. And I'll come on to that in due course. That is one particular error, which is, in our submission, very important. I will structure the first part of my submissions in the way that the judge has dealt with it, going through the points he makes in respect of each family member in turn in the order that he deals with it. And then in the second part of my submissions, I will deal with the improbabilities aspect, which he, in our submission, did not deal with as he should have done. Yes. In short, just to summarise what we are asking your lordships to find is, in respect of the veracity assessment, it's our submission that several of what the judge regarded as discrepancies are based on errors by the judge, and such discrepancies that remain are of the type of inconsistency that you would expect from witnesses of a split-second event in accounts spread over more than a year. We would also submit, and I will refer in respect of one or two of the witnesses as I go through them, to the way, or what they said rather than the way, what they said in their evidence, which in our submission is much more consistent with a truthful account than a false account.
To confirm that we received the transcripts yesterday.
Yes.
Yes, I'm sorry that it took so long to get them, but they've arrived, and we've had the chance to study them.
I'm not going to. There's only a very few passages that I will refer to.
Just confirming
just to
that those papers we have.
Yes, I'm much obliged, and I'm sorry that they took so long to get to you. So, dealing with the witnesses in the order that the judge dealt with them, we start with the mother, and there were really three points that the judge relies on in respect of his evaluation of the mother, taking them one by one. His first point is that in her oral evidence, the mother said that just prior to the fall, the child was clapping. And the judge said that the mother had never said that ever before. And that's right, she had never said it ever before.
Just pausing. The passage of the judgment that relates to the mother is 182 to 185, is it not?
That's right, 185.
But the whole of the passage is between those 4 paragraphs.
Did you ask me to read it?
Not at all.
No.
No. But I'm just checking that we've got.
Yes, no, that's right.
the-
Yes, I'm sorry, I should have referred to the paragraph.
section that you're concerning yourself with. Right. So the first is the clapping.
The clapping, and the point is that she didn't say clapping. The judge got that wrong. She said, as she'd always said, tapping, and the judge listened eventually to the audio of her evidence and agreed that she said tapping. The second point that the judge relies on is that the mother, in her police interview at page...
Sorry, can I just... on that first point, sorry,
Yes.
I don't follow what you're saying. The judge's point was that the mother had never said before that the child was clapping.
Yes, that's right.
Okay, well, if you just substitute tapping for clapping, sorry, the point is, was there mention of that action, whatever it was, whether it was tapping or clapping, at any earlier stage?
That's
That's what the judge
never mentioned clapping in any of her previous statements.
Right, but did she mention tapping?
Oh, yes. She mentioned tapping.
Okay.
The judge says that, you know, that was what she'd previously said.
If we go to paragraph 184, the judge recites the mother's evidence and says she was clapping hands. Right. Now that is a mistake.
That is a mistake.
The transcript shows it was a mistake.
Yes.
It's not a very big mistake, but nevertheless, 3 lines later, paragraph 185, however, her description of Marwa clapping, forgive me, I've done what I said I wouldn't do, was not one that I'd come across in her statement. And so, in some small way at least, the judge appears to be casting doubt on the mother's reliability.
Yes, indeed.
By reference to having come up with something in the witness box which she'd never come up with before.
Absolutely, yes.
That's your point.
That's my point. Yes.
And the judge accepted that.
And the judge accepted it, though, of course, he said when his errors were pointed out to him that none of these errors that he accepted made any difference. But the question one asks when one goes through all this is, what's left for him?
Yes, right. Well,
to base his judgment on. The second point that the judge relies on is that he refers to her police interview. At 2 places he refers to it, at CB 257 and CB 275, when she's being interviewed by the police officer.
right. Are these the references in paragraph 185 by another?
185, yes.
Right, by our.
Yes, those references are there, and the references in the police interview as the pages I've just given, CB 257 and CB 275. The judge's point here is that in her police interview, which was on May the 17th, just less than a week after the actual causative event took place, she did not refer to the child falling on the right. Whereas, the judge says, in her witness statement at C42, the mother says that the child fell and her right head hit the floor.
And the date of that statement, remind us.
I think he refers to that in paragraph 183.
Yes. I'm just looking for the mother's statement 27th of July.
Yes.
22.
What's the CB reference to that? It's at C42.
147.
CB 147. So the point the judge is making is that the mother is adding a new detail in her witness statement of some significance, not mentioned to the police only a few days after the incident. No mention of a fall to the right. The judge's error in this respect, and in our submission it's a very significant error, is that in her police interview at CB 285, in answer to a specific question, the mother said, her right side fell down. That's at line 1. And at line 4, on the same page, she went towards the right. It's our submission, therefore, that this is a serious mistake by the judge. He is relying on the fact that when it would have been fresh in her mind, she didn't mention a significant point and only comes up with it sometime later in her witness statement. But she did mention in her police interview, in 2 places, that she fell to the right.
Right. The sum of this is at the end of paragraph 185,
Yes.
which is that the point that the judge is making is that he can't reconcile
Oh, that's
how assured the mother is in the witness box.
That's the third point I'm coming on to, yes.
Right, but I'll let you make your third point and we come back to it then.
Yes.
Yes.
He's made a mistake.
Yes, I think we have the second.
Yeah, that mistake. Then the third point that the judge relied on, as your lordship rightly points out, is that he made a comparison between the mother's assured giving of evidence and how vague, by comparison, she was in her police interview. In 185. In our submission, the judge is simply wrong in making this comparison. First, the judge does not...
Before we look at that, I had assumed vague by comparison referred to the 2 points that he just...
Well, he doesn't...
enumerated.
Maybe, but he doesn't give any other...
Right.
He doesn't give any
So
other...
you're going to deal with the possibility that he was referring to a general impression of vagueness in the...
He may have been.
All right.
Yes. Yes.
Understand.
First, the judge doesn't give any other example of vagueness in the interview, other than the point that your lordship has mentioned. And secondly, more generally, we submit that the mother was simply not vague, either in respect of the direction of the fall, as we've just established, or more generally, if the judge was relying on that. And a third point that
we have the mother's police interview at 251.
Yes.
I think, and that's a substantial interview,
Very substantial.
lasting for better part of 2 hours and covering 62 pages.
Yes, and that's right. And it's our submission. She wasn't vague in this, and a point which has to be borne in mind is that in comparing statements made by a witness on different occasions, for example, in an interview on one occasion and in court, being questioned by various lawyers, the nature of the circumstances differ, and that has an impact on the answers.
Sorry, I'm excuse me for trying to play catch up here. There are 2 instances in 185 which you have separately mentioned. I think the reference, incidentally, to the police interview is at core bundle you said is 285, which is G801, and I think your basic point is that although the judge referred to the police interview at G773 and G791, he didn't refer to what was said at G801, and that was the key, because
that's a clear mistake.
The mother said her right side fell down, she went towards the right, and then her head hit first.
Yes.
So that's your point. So you've dealt with those 2 points.
Yes, and I'm going on to explain the reason why the mother was, if you like, not so specific in the first 2 references that the judge relied on, and why she was more specific later in the interview.
Yeah, but but if you've dealt with the 2 instances the judge refers to in 185, in a sense, what is there left that this court could grapple with in terms of some other impression of vagueness or otherwise? I mean, there's nothing to go on.
Yes, if that's the view the court takes, then I can move on. But I wasn't.
Before you do, I take my lord's point. But if one looks at 257 to in the police interview,
258.
257, 258. Yeah. I mean, what you have there is a voluntary interview, which whether it's true or not, could scarcely be described as vague. I mean, it's a narrative account
it's
of an event, whether it happened or not.
She was actually asked. What she did was she was asked to tell the police officer what happened the whole day, and that was 2 pages previously. That question was asked, and then she has a narrative, and the references that the judge relied on came part of a narrative when she wasn't being asked specific questions. But the passages that where she does refer to the right is when she's asked specifically about the fall. Please describe the fall, and then she does. So that's the point. And she's asked actually on there are 4 occasions when she talks about the fall. The 2 that the judge describes. There's the one that I've already referred to, where she describes the falling to the right. And then there's a 4th occasion where she's asked another specific question about the doll, and she gives a specific answer to that. In our submission, the judge indicates not only that he's wrong about the particular point, but it shows a very superficial understanding of this part of the evidence, the whole of the police interview. He should have known that she said on later pages that there was a fall to the right, and he should have been aware of why there was that difference that we've just outlined.
Well, the sum total of this, as I understand your submission, is that when one looks at it objectively and sees that there were a couple of specific comments which can be dispelled when one looks at the record, we're left with no critique, no criticism of the mother as a witness at all.
At all, absolutely. That is our submission. Those are the 3 points he relies on, and the mother might well ask, how can he find I was a liar when he got all those points wrong?
Well, I keep saying you've got an anterior complaint that you say found I was a liar, but that's not a finding in the judgment. It's an inference from the judgment.
It's an inference from the judgment.
Yes.
Yes, indeed.
I mean, if you're to succeed on this appeal, Mr. Newton, one of the reasons that you are bound to succeed on is that if people, particularly people of good character, come and tell a story to a family court or indeed to any court, and they're going to be disbelieved, then the court has to say that it disbelieves them. And why?
Indeed.
That's why the assessment of the lay evidence is so important.
Absolutely. Absolutely. And there are, of course, six individuals of entirely impeccable character prior to this who have suffered the same point.
Well, not all of them say that they saw the incident. Some of them talk about peripheral vision. So,
yes.
And
Yeah,
you're in danger of starting to hop to bits of the evidence rather than giving a fair impression of what was before the judge.
Oh, well, yes, I was going to go through each.
With some encouragement, no doubt.
Yes, I was going through each one. the peripheral evidence point is one that in my submission, if it were a lying account, why would a witness actually talk about peripheral vision rather than just say that they saw it happen? That's one perhaps indication that they are trying to tell the truth and explain why they can't give the detail that they otherwise would like to. Yes.
Right,
Right,
that's
well,
the mother.
there is a fourth matter relating to the mother, which the judge didn't seem to rely on, but again, it ought to be spelled out. It's another factual error. He says at paragraph 184, dealing with the mother's oral evidence in chief, that the mother said the right side of the head hit the doll and on the floor. The transcript of the mother's evidence at page 9 of the transcript, line 19, reads, the right side of her head hit the floor, and when she landed, then the doll was under her back. What the mother said in her oral evidence was what her case had always been, that the head hit the floor and the doll was under her back. The judge made a mistake as to that particular part of the evidence. So that's another factor of another error made by the judge in respect of the mother. But what perhaps one can also say is that it's particularly...
I was just looking for the transcript reference. You said line 19.
It's page 12 of the bundle.
Page 12, thank you.
It's page, oh, right, it's page 9 of the...
Internal 9, but page 12.
12, 19.
Yes, page, right.
And I think we gleaned from the transcript that the police took the doll. The doll wasn't itself available, but a stand-in doll was produced by the family,
court, yes.
Which was treated as being
The right doll.
the right sort of doll.
Yes, it was a soft doll, yes. But perhaps it's significant that the judge, hearing that setting out in his judgment that the mother had said that the head hit the doll, what's significant is that she'd never said that before. It was never part of her case. And it's significant that he didn't raise it either with her when he thought he heard that during her evidence, and also significant that he didn't seem to rely on that particular apparent discrepancy in her, quite a significant discrepancy in her evidence. If she had said that for the first time that the head hit the doll, he didn't seek to rely on that as a discrepancy. It's surprising that he didn't pick that up. Surprising that he made a mistake in the first place, perhaps, and surprising that he didn't actually make any comment about it.
I understand you say this, we're entitled to look at actual mistakes that the judge made. I mean, that last criticism comes perilously close to sort of just asking us to effectively deal with things that the judge didn't deal with, but perhaps you say should have done, or put weight on things that he...
Well, it's another factor of his judgment which shows that he wasn't on top of the evidence. If he had been on top of the evidence, he would have realised that what he had thought he'd heard was completely different from what she'd always been saying. It's just confirmation in our submission that the judge simply was not carrying out a proper veracity assessment. Now, so that's the position in respect of the mother. Moving on to the father, there is one point. This is at in the judgment at 186, paragraph 186, the judge refers to the fact that the father at CB 325, I think, said that he was told by the mother that suddenly the child, I'm sorry, I'm looking at a wrong reference. Let me just go to 186. Yes, it was in his witness statement that C78 that the judge referred to the fact that the child, the mother said prior to the fall, was jumping up and down, and she'd never said that before.
Sorry, can I just take the, so we don't have to do this more than once. Just take this slowly. So where do we start? CB 78.
CB 78 is the place where the
Core Bundle 191.
Thank you.
yes 191 jumping up and down. That's right. It was at G 841 Core Bundle
Just wait a
325.
wait a moment. Yes. No, sorry. I've caught up.
It is correct that the mother had never said jumping up and down on any other occasion. But when the father at in his G841, his police interview, CB 325, was asked about this, he said, suddenly she'd do something like the child to, and then the word is bubbling, question mark. We don't know what precisely he was saying, or something like that, and she fell back on her head, as being something that was told to him by the mother. There is the fact that the mother did not say jumping on a previous occasion, on any other occasion. But the mother consistently, in her evidence, in her accounts, referred to the child moving. And the other witnesses, for example, N, the sister N, refers in her interview with TDC Bacchus on the 12th of May, suddenly she moved. And SA, the sister, SH refers to a sudden move. Now, so there were different ways in which the mother referred to what caused the child to lose balance. The local authority, no question was asked of the mother relating to this. It wasn't suggested.
Sorry, I'm struggling again. I mean, are you saying, I think you're saying in 186 that you accept that the sentence that no one has suggested that the child was jumping up and down when she fell is correct? But what you're now doing is to say, yes, but there's a whole load of other evidence.
Yes.
But on what basis are we doing this? I mean, you're just basically asking this court to reevaluate the...
Well, the judge should have taken into account the other evidence there was of what the mother said about movements, and what other witnesses said about movements, to see whether, to put it in the context and see whether the fact that on one occasion she is alleged to have said jumping up and down.
But what is wrong with paragraph 186?
Well,
in terms of the assessment of the father's evidence?
no, it's how you carry it on from that. He's not got the evidence wrong on that occasion. But the point is, what do you make of it? If he's relying on this as a factor which indicates that the mother is not telling the truth.
Where do you say that?
Well, in what way is he relying on it?
Yes, the point that you're making, as I understand it, is that the two middle sentences in paragraph 186 are there in order to cast doubt upon the family's account, although he may mention them without carrying through and explaining why they cast doubt on the family's account or what the significance is. And if he was going to do that, then he needed to look at all the evidence that.
You should look. That's exactly the point.
Is that the point? All right. Well, we've got it.
We've got yes. Thank you. Yeah. And I also make the point that the mother wasn't asked by anybody about that point. No, the local authority didn't rely on it as an indication of any dishonesty by the mother, and that's important because, there's usually one is meant to put to witnesses points that you're relying on.
All right.
I then turn next to N, which is in the order of the.
Yes. Well, we've seen. I'm glad to see that family members have arrived. One of those is your client.
Yes. Yes. She's put her hand up to indicate her.
Yes.
Yes.
And anybody else that we know, or it doesn't matter if not.
SH is here as well.
And SH. Thank you very much.
Yes. Turning to N, really what's relevant to N is the whiplash point. I've dealt with this in the skeleton at paragraph 13A on page 7 of the skeleton. And I don't want to really add very little to what is said in the skeleton there. The judge's point is that N referred to the injury or the effect of the fall being like a whiplash in her telephone interview on the 14th of April 2023, but not in her witness statement, which she provided a few months earlier, without referring to the first statement which she made on the 12th of May 2012. The judge's point is that he is giving reliance on a factor in respect of N that causes him to doubt her veracity because she said about whiplash in a telephone interview on the 14th of April 23, which she hadn't put in her witness statement 3 months earlier. But he didn't take into account that she had mentioned in her very first account, the day after the incident, something which does indicate a mechanism which can be likened to whiplash. And that's in her her witness statement. Sorry, not in. It's in her. It's in the bundle at CB 234 when she is talking to DC, temporary DC Bacchus. At CB 235, I think at the top of the page, it says, I was holding on to her top, left hand holding top holding her up and right hand on the bum, took right hand off, and then suddenly she moved and lost my grip on her top. Just went to pick up with milk bottle, and then she fell. Question was asked, what was the child doing at the stall? Answer, playing with her teddy. Question, did you see her fall? Answer, yes. And this is the point. Went to grab her, but too late. I picked her up, and she was quite hysterical.
I'm not yet getting the point about the whiplash.
I think you just, with respect, I think you're probably, I mean, I'm not sure I'm getting the point here as to why we're doing it, but is the point actually on the previous page,
Yes.
234, just above the last question?
Yes,
Yes.
no, you're absolutely
head
right.
fell
my
backwards.
lord. You're absolutely
Yes,
right.
that's
It's,
the point.
fell back onto doll with lower back slightly raised, so head fell backwards. That's the passage I should have read. I'm sorry, I had highlighted the wrong passage.
And why is that whiplash?
It indicates that she fell back onto a doll with lower back slightly raised. So, it's the word so the head fell backwards. She's landing with her back on the doll. It's an indication that the falling with her back on the doll was causative of the way that the head hit the floor. So head fell backwards.
And these are notes taken by the officer the following day.
That was a note taken by DC Backus the following day, 12th of May, which the judge did not refer to at all in his judgment. That's the only point in respect of N. In respect of SA, I turn to next. The matter that the judge mentions is that in the 999 call, she said, to quote from paragraph 189 of the judgment, the child had fallen just from the sofa down to the carpet as she lost balance as she doesn't walk. The point that may have been in the judge's mind in stating that is obviously that he might be suggesting that SA was saying that the child had fallen off the sofa, which of course no one, that was not the account of anybody. It's not entirely clear whether the judge did interpret it like that, as later in paragraph 189 he goes on to refer to an explanation that what was meant by SA was the distance or height of the fall that results from a passage in the evidence where that seems to have been something he relied on, or may have relied on. There are three, dealing with what may have been in the judge's mind, and he may have been relying on this as a matter suggesting that there was an account, first of all, that the child had fallen off the sofa, which no one else has ever said. There are 3 points that I want us to make in respect of this. The first point is that it's essential to read the whole of the relevant part of the 999 call transcript. The summary of the 999 call is at CB 226. And one should note that the summary at the top states the summary is said to be not verbatim or exhaustive. And then I would refer to the relevant part of the summary of the 999 call, where it starts, how far did she fall? And then the answer is, just from, ... not far at all, ... just from the sofa, or just from sofa down to the carpet. I should stress here that the ... are quite, in my submission, quite important. What caused the fall was the next question. Just lost balance, she doesn't walk. I now turn to what SA said in her oral evidence.
Was there any other transcript of the 999 call, or was it played in?
No, there was no other transcript. We were able to listen to it, but it was, that was, I think we all listened to it at some point, but we all relied at the hearing on this short summary.
And you said in your submissions that the ... was significant. Why?
I'm coming on to deal with that now,
right.
in respect of SA's oral evidence. And we find her evidence starting.
Sorry, just to be clear, are you saying the ... is that there's something missing from it, or is that just signifying that there was a pause?
Well, let me go to her evidence and
well, you've listened to the call.
Well, it's
so
either that there was just a pause, or there might have been something missing. Can't be sure about that. But if you let me refer you to the evidence first, then it will become clearer what I am seeking to say. It's at page 64, lines 18 and onwards.
Was it transcript?
Of her transcript? Yes. The transcripts are in two tranches, one shorter and one longer. This is the longer tranche of transcripts.
So that would be page 67 of the
right.
bundle. Is that right?
Yes, I'm looking at 64 of the transcript itself.
Right.
Yes.
It may be in the bundle. It's 3 pages.
It is 67 in our numbered bundle. Thank you.
Thank you.
Right.
Was it you that spoke to the emergency services? Yes. Yes. You talked about a fall from the sofa to the carpet. I panicked. I couldn't. It's not your ordinary footstool, so I couldn't really think of the name of it. It's an Asian stool kind of thing. So that's why I probably said sofa at the time. It's just that it sounded as if it was a fall, sort of from the sofa, not a fall over or fall from it. The lady on the phone asked me how far did she fall from. Right. How far she fell from, so I said not far at all, and I couldn't write. I couldn't remember what to say, that's all. I said from, like the sofa, for instance, meaning as in she was leaning against the sofa. That's what I was trying to say. Whether that was understood like that, I don't know. So if we return with that in mind, with her evidence in mind, to what the transcript of the summary of the 999 call was, how far did she fall? Just from ... not far at all. In our submission, the just from ... not far at all is most easily and probably explicable in our submission by the fact that she was struggling with how to describe how far it was in the way that she's indicated in her oral evidence. She didn't know what the right word was from...
We have the point.
You've got the point. There we are.
Right, so that's two of your points. Is it on this? Is there a third one?
That's right. Yes. The next point relating to this is that SA is a nurse. She would have realised that the serious injuries that her child was displaying would have been unlikely to have been caused by a trivial fall. So if she was giving the account of a fall in the 999 call as a way of trying to cover up that there was something more serious that happened, it's, in our submission, very unlikely that she would have been downplaying the nature of the fall.
Was there any exploration of what type of nurse she was?
Yes, she's a non-ward-based cancer nurse.
Oncology.
So what is the evidential basis for the proposition that she would have immediately guessed this was an unlikely cause for the injuries suffered?
If we go, I think it's at page 64, where we were before.
What, in the transcripts?
Well,
Are we talking about her work here?
yes, where it goes at the bottom of the page, line where I stopped, carry on.
Yes.
And it is apparent to you as a nurse, I'm assuming, the moment you saw Marva after whatever the incident was, that she was a very, very ill baby. After the fall, yes, very ill, and that they needed to get help. That indicates that
But that's not the point you've just made, which is she would have known that the fall couldn't have caused her to be very, very ill.
Yes, well, I'm asking the court.
Is that a point you made to the judge? If you're going to criticise the judge for not putting it in a judgment, and it's not on the evidence, how could the judge know that?
Well, she's a nurse.
Right. Well, that's the point. Shall we move on?
I think. Excuse me just a moment, if I might just. What is 249? CB 249. Top of the page. And that's where she's saying it from here. Yes. Yes, well, there is another, I beg your pardon for that, but I wanted to check another reference on the point that Lord Justice Dingemans made. There is a reference at CB 249.
Yes.
At the top of the page, this is SA being interviewed.
2nd of November 22, police telephone interview.
DC Huddleston, I think.
Yes.
Who was in the room at the time? Have you discussed the matter since? No, nothing different.
Well, if you go back a little bit to 247.
247.
This point is dealt with directly in the police interview. I've listened to the 999 call. You have that passage? Then cites the parts you've just been showing to us. and then how far did she fall in terms of height? It was from her own height. Her feet were on the ground, etc., etc. That's the bit you want to refer us to?
No, it was a passage which relates to the nature of the fall, and the passage where the witness says, "I panicked."
Yes, that's 249, 4 lines down.
Yes. No, nothing different. I'm a nurse, and when it all happened, I was very odd. She fell from such a small height. I was panicked. One interpretation of that is that she saw the severity of it and realised that
Really,
it's
Mr.
unusual.
We're not in this court concerned with interpretations.
Right.
If there are things where you're able to show us that the judge said something which either he accepted was not correct or can't have been correct, then that's a different matter. But can we now begin to move quite swiftly through these points of detail?
Yes. I am very close to going through them all. The other matter that the judge seems to have relied on in respect of SA is that SA gave a more detailed account in the telephone interview on the 2nd of November, DC Huddleston, the one that you've just been looking at, than in either her oral evidence or her witness statement. I'll just, without going through the detail of that, I will just indicate our particular case on that. Our submission is that the reasons for the differences between the telephone interview and her oral evidence derives from the fact that she was asked different questions. The reason for the differences between her telephone interview and the witness statement and her witness statement derives from the fact that she was asked particular questions in her telephone interview, and she made her witness statement without legal representation. And the overriding point is that in any event, there is no difference in substance between the accounts.
Yes.
Before departing from SA, I do want to refer to 2 passages in her oral evidence, which in our submission strongly suggest that SA was giving a true account of the fall. The first passage is at her transcript 63:18. When she was asked by counsel for the local authority, did you see the fall, or were you sort of just aware of the aftermath? You were all talking. I was in the same room, but I wasn't directly looking at Marwa, but I do have some recollection, if that makes sense. Yes, I did see the fall. Do you actually see her, or did you kind of be aware of her hitting the floor? Do you see what I mean? It was more inaudible. Yes. So yeah, I can't be sure what angle she fell, and that's what I've written in my statement as well. But she definitely fell and hit her head. I know that for sure. That's that first passage, and the second passage is a few pages further on, at page 67, at line 21. This is when the judge is asking her questions. But during the course of the evidence that you've given, and certainly the answers that you've given, really to all the parties, you appear to be absolutely sure and very certain about what you saw. Just look near the bottom of 758. You were asked here what part of her head hit the floor, and you said, not sure, it may be the side. You didn't appear to be so certain there. Do you see it? Sorry, 758, right down to the bottom, 3rd line. I'm still not clear that she hit the side now, but she definitely hit her head on the floor, is what I'm trying to say. So you do not know whether it was the side or, I can't be sure. No. Is that because you didn't see the fall in that sense? Yeah, like I said, it was my peripheral vision. I think inaudible, but I can't be certain. It was her side, but I know she hit her head. So it was the side. I mean, here you said to the officer, not sure, it was maybe the side. Yeah, so maybe it was the side of her head. But you are sure? I'm not sure. Or is it that just a guess? I mean, you tell me, you were there. From what I remember, she fell. And the angle she was standing at when she fell, it now thinking about it, is probably definitely the side, but I can't be 100% sure it was definitely the side. I mentioned those two passages as passages of the oral evidence of the parties, which it's difficult to, in our submission, to think that that is a lying account, that she is telling the truth as best she can, describing what she remembers of the fall and the imperfections of her vision of what happened. There is another feature of SA's evidence where the judge mistakenly considers there is an inconsistency. I set this out in the skeleton.
Yes,
at
judgment.
page 12.
What paragraph in the judgment?
It's judgment. It's let me just get the judgment. 1-9. $190.
Yes.
I've dealt with this in our skeleton.
Right, what's the inconsistency?
At page 12, paragraph 14, little 2. I refer the court to that, and unless you want me to go through it, I would just not add anything to that. It's another example in our submission of where the judge has made a clear and obvious error.
Right, just a moment.
I can develop that a little, or just read out what we say in paragraph.
I'm just trying to get to the reference. You said your skeleton argument. I'm not finding the paragraph reference you've just given me.
It's 14, little 2. One discrepancy mentioned by the judge results from his own misunderstanding of the evidence. In paragraph 190, CB 96, the judge says that in her telephone interview on the 2nd of November 2022, that's CB 247, Sabiha recalled that the child had her hands on the stall, but remembered that her hands were around her waist at one time. There is no other account that the child had her hands around the waist, but it is quite clear in our submission that the judge has misinterpreted SA's account. SA clearly meant that her sister N had her hands around around the child's waist at one time. It's quite clear because the question that was asked of her related to how N was holding her. And the answer is focusing on how N was holding her. And so the judge should have realized that what SA was actually saying was that she remembered that N's hands were around the child's waist at one time, rather than she was remembering that the child's hands were around her own waist, which no one had suggested. In our submission, that's a clear and obvious misinterpretation of the evidence. And the key to it is the question which is asked.
Sorry, why do you say that? I mean, this is doing something which this court is always told not to do, which is you're construing paragraph 190 as if it's a statute. I mean, why do you say that the judge mistakenly there thought that the child had her own hands around her waist, as opposed to the alternative interpretation, which is that somebody else's hands were around the child's waist, which is a perfectly sensible way of reading that sentence. Why do you say the judge must have, when the judge wrote that sentence, have taken the wrong
ordinary
view?
way of reading that is recalled that the child had her hands on the stall, but remembered that her hands were around her waist at one time.
Well, there's she at the beginning of the sentence could be the first her. There are a number of different ways of reading that.
The key to it is that what was the question she was being asked, and she was asked to say how was N holding the child.
But the problem is that you're picking a sentence out of this judgment. You're saying it must be taken that the judge misunderstood whose hands were around the child's waist and thought it was the child's hands were around the child's waist, and that was wrong. It's perfectly possible that sentence actually just reads accurately. That there was somebody else's hands around the child's waist, and what you're doing is island hopping from sentence to sentence and just picking a particular point and then saying, but the judge must have got that wrong.
Well, it seemed to us that the judge was seeking to make a point that he was relying on in saying that the child had that there was a recollection that the child had a hand somewhere where no one else had ever said
Miss Newton, speaking for myself, I hadn't even seen that. I mean, in your defence of the charge of island hopping, we've spent all the time so far on 10 paragraphs of this judgment. And you're seeking to show us that actually there's nothing that can be properly criticised so far as the family is concerned in any of those paragraphs.
Yes.
Actually, that wasn't a point that I took as being a critical point, so you may be
I'll
not
move
needing
on.
to deal with it.
Yes.
So can we move on?
Yes. We go on to the maternal grandmother. There are 3 points here. I'll take them as quickly as I can. The first point is that at paragraph 191 of the judgment, the judge claimed that there was an inconsistency between her witness statement, where she says that the eldest daughter got the milk, and her oral evidence, which the judge said, in which the judge said she said that N got the milk. The judge heard the transcript, heard the audio of this, and agreed that he was wrong, and that in her oral evidence, the witness had said that it was the oldest daughter. The transcript reference is 73, line 12. That's the first point, a clear error which he acknowledged and said it made no difference. Then in paragraph 191, the judge says that in her oral evidence, the maternal grandmother stated that she saw the child fall to her side, but couldn't recall whether it was right or left. She recalled seeing the child's head go down to the floor. Whereas in her witness statement on the 18th of January 2023, CB 220, she said that she didn't quite see how the child fell. And the judge seems to have relied on that as a significant discrepancy in his veracity assessment. It submitted that there is nothing in this difference. They're not really inconsistent with each other, but both suggest a degree of uncertainty. The witness statement was written with the help of her son, not with any legal representation. It's a very short witness statement. And her oral evidence was, of course, subject to more questions. Yes. Then we come to the third matter in respect of the maternal grandmother, which relates to the telephone interview on the 21st of May 2023, which is dealt with in paragraph 192 of the judgment. It is dealt with in our skeleton. On page 6, in paragraph 12. You'll recall that this was the point that in the telephone interview, which was conducted with an Urdu-speaking police officer, that the record of what the maternal grandmother said was that the child had stood on a little stool and all of a sudden fallen off the stool. In her oral evidence, no one put to the grandmother that this represented an account which was so significantly different from what she says on other occasions, and indeed in her oral evidence, that it was an indication that she is not telling the truth. No question about this was put to her by anyone, including the judge. It wasn't relied on by anyone. And it was our position, on behalf of the mother, that it was clearly an obvious and very simple translation mistake, just probably relating to a preposition as to what the nature of the fall was.
Right.
And we, as I say, we set out in greater detail our submissions in respect of that on page 6 in paragraph 12 of our skeleton. And I would invite your lordships to. I don't want to add anything to what we've got there. I've put everything I want to say there.
Can we move to the next witness?
Sorry?
Next witness.
Yes. And the last, the eldest daughter.
Yes.
The judge deals with the eldest daughter at paragraphs 194 to 198. The main point made by the judge in respect of the eldest daughter is that the eldest daughter said on the 12th of May to TDC Bacchus, "I saw the child fall backwards and head went backwards." Whereas in her police interview at CB 357 line 5, she said, in answer to the question, "You didn't actually see her fall?" "No, I didn't." And in her witness statement of February 2023 at CB 223 in paragraph 9, she said, "I didn't see what happened." And in her oral evidence, she agreed with the local authorities' question, but that she didn't see the fall. She agreed with that. So, judge's point is, the day after, she says that I saw the fall backwards and her head went backwards, and she doesn't repeat that. In fact, she contradicts that on those 3 points that I've just made. Now, in respect of this, I would ask your lordships to bear in mind the following. What must be borne in mind is that on the family's account, when the child fell, the eldest daughter was sitting on the sofa right opposite where the child was standing at the stall, and only a few feet away from where the child was standing. And the child would have fallen more or less in front of the eldest daughter and only a few feet away. Even though preoccupied on her phone, given the proximity of those circumstances, in our submission, it's virtually inevitable that the eldest daughter would have had some awareness of a fall occurring, even though not looking.
Yes, I think these are submissions that you could address to a judge, but I don't think these are ones that are helping us.
Well, it's important to bear in mind the circumstances in which.
Yes, well, I've given you an indication about that, Ms. Newton.
Yes, I'll go on to say another point is that it is, of course, possible that a person's recollection is better less than 24 hours after the event than subsequently. And the first account, when she said she saw it, was less than 24 hours.
Right, that's a submission of precisely the same kind.
Sorry?
It's a submission of the same kind,
Well,
which is one that we cannot really make much use of. Now, anything else in relation to the eldest daughter?
I would ask you also to bear in mind what she actually said about her condition in the period after the fall, leading up to when she was interviewed by the police. She said at her transcript, 23, line 31, she was asked to describe the effect of what had happened on her.
Just a moment, because your references are not the same as ours.
Transcript 23. Oh yes, that should be perhaps 26 then. Should it, in your bundle?
Yep.
Yes, she gave rather long evidence compared to
Yes.
the others.
Yes. And what she said orally is also important.
So where are you? So where on page 26 of the transcript bundle are you asking us to look?
It was page. Well, I have my references. Let me just find it.
Internal page 23, line.
Line 31.
Thank you.
Sorry, unless I got it wrong. My internally numbered page 23, line 31 reads, I think that was just once. I think she probably said that. Is that where you want us to look?
I'm looking at
No,
transcript
I was
on page
referring.
109.
I was referring to the bottom of my
Oh, right.
page
Sorry.
23.
So-
My sister was in hospital.
Sorry, it's 109 of the transcript bundle.
109, yes.
Sorry.
I'm sorry. The transcript bundle arrived yesterday. I don't know what pagination everybody
Yes,
else
right.
has.
Sorry, okay, right.
Okay, she was. Remember looking, I just don't remember why I didn't say anything. I was
That's the-
frustrated, it just happened. My sister was in hospital, everything was overwhelming. That's the passage you.
Yes,
You
that's
want.
right. That's
Yes, right,
Yes. Yes.
We shouldn't forget, I'm sure, that there were two other people in the room at the time as well, that, according to the family. There was a 10-year-old and an 8-year-old
Yes.
who nobody spoke to about any of this.
No one spoke to about it at all. No, not interviewed.
Did anybody comment on that at the trial?
Not in front of the judge, I don't recall. I think
Right,
there was
all right.
obviously comment other than that. Yes. But
Yes.
going back to what the eldest daughter said about the point we were on, she said in her oral evidence that she'd seen the child fall based on her assumption. At page 24, line 27, she said, I assumed she fell backwards. And she consistently said in other parts of her evidence, not her oral evidence, but the statements to other people, that she saw the child laying on her back. That's in the police interview. She said that at CB 348, line 7. She was lying on her back on the floor. In her witness statement of February 23, at paragraph 9 on CB 223, she said, I saw the child on the floor, on her back. and in her oral evidence, as we've just indicated, in her transcript at page 20, lines 16 to 22.
So, sorry, I'm not sure what this.
The point is that she consistently says that she saw the child lying on the floor on her back, and that she assumed from that the child had fallen.
Yeah, and the judge's comments at 194 to 198 are simply to draw a distinction, or to comment on the fact that there was a difference between, for example, the first police interview referred to at 195, where the eldest daughter said that she saw the child fall backwards and her head went backwards, yes, to other parts of other evidence given on other occasions where she effectively said, I didn't actually see it, I didn't see a fall, yeah, I just saw her on the floor afterwards. And all the judge is doing is commenting on the fact that there were differences in that element.
Well, yes.
Where do we take this?
Well, the judge seems to have relied on that difference as a factor for finding that she, or possibly finding that she was not telling the truth.
Well, I mean, putting aside the bigger question, which is, did he so find, and should he so find, or should he, which we raised at the start, are you saying the judge couldn't have taken such differences into account, that he was wrong to take such?
Well, if he takes them into account, he should take it into account in the context of the other relevant evidence, and he didn't do that. And I've pointed out the other relevant evidence which the judge didn't take into account.
But they're just other illustrations of the difference between the subsequent accounts and the first account given, yes, to the police officer on the 12th of May. So why does that change anything?
I've made my submissions on that. I hope I've been going through this, that she consistently said that she saw the child falling on her back. She assumed that the child had fallen, and
she said at the start that she had seen the fall.
Yes.
To the police officer, but then in subsequent evidence, she did not say that she saw the fall. The transcript you've just taken us to indicates that all that she saw was her on the floor and did not see the fall, and that's the difference the judge is referring to. So where did it go?
Well, she also said to the judge that she could not recollect whether she saw it. If one goes to the transcript 24, line 9, you didn't see her fall, the judge says to her. Not that I recollect. I don't remember. I don't remember seeing her fall back.
Yeah, and at 25, line 25 and 26, you never saw her fall backwards? No. I said that because she was on the floor backwards when I saw her. Yeah. So I just assumed she fell backwards. Yes. All the judge is doing is saying that's not the account given to the police officer at the start.
Yes.
So are you saying the judge was wrong to draw attention to the fact there had been a difference?
No, but he's wrong, not wrong to draw attention to it. He is wrong if he is relying on that as one of the factors which leads him to doubt the credibility of the witness, because he hasn't set it in the full context of what the witness said.
Well, could we end this passage by just looking at 237, which is where it starts, which is the first account given by this young person in the call bundle, 237.
Yes.
Bottom of page. That is a note taken by a police officer of as part of a series of discussions with the family. It's not a verbatim account. It's a note of what the officer was being told. And that's the extract the judge had in mind. You might have said, and the judge might have accepted, that actually there's not much to distinguished between the various accounts, where you bear in mind one's a transcript,
Well, indeed.
when you can see the questions, one isn't. But there it is. I
There
think
it
the point
is.
we're trying to make to you, Mr. Newton, is there it is,
Yes.
as so far as that's concerned.
But I've been going through the points which the judge in his
Right.
roundup passage at the end, which I referred to at the beginning. He refers to the discrepancies that he's relied on.
Right.
In a general term, he doesn't actually specify them, of course. So one has to go through them. And in this case, it's quite right. I started my submissions on this point by outlining the very difference between what she said first and then what she said later. But then I wanted to set that into the context of what else she said and the reasons for it. I mean,
Now,
yes.
we finished with that witness.
That's the end of the witnesses that he evaluated. There is an important point to make, however, in respect of SH, the sister SH. She has, of course, been joined as an intervener, but the judge has said he read her evidence, but he has not given any evaluation or assessment of her evidence. He's given no indication as to why he has concluded, or may have concluded, that she has not been truthful, why he has included her in all the witnesses whom he has found not to have been reliable.
Right. SH is referred to paragraph 72 of the
Yes.
judgment in terms of her
It's about
summary.
2 lines.
Yes.
That's all she gets.
Referred to there, so its statement is read and the judge does not return to pick that up or comment on her oral evidence later. Is that your point?
That's the one. That's SH. That's it. There's nothing in his assessment of the lay evidence at paragraphs 180 and following. In our submission, it was incumbent on the judge to evaluate the evidence of all of those in the pool of possible
Is
verdicts.
that something that he was asked to do in clarification?
The point,
I can't remember. There were so many points of
it
clarification.
was, yes.
Right, and so let's, in fairness to the judge, look at what...
Yes. He says he read her evidence. He doesn't actually...
Well, let's see, you...
In the clarification transcript, it's at CB 108, and in the clarification document at CB 112, he refers to it twice. In our submission, what he says there is not an evaluation, it's totally inadequate.
Well, I don't have in my mind what was in paragraph 14E1 of the clarification document, but I can't even remember whether we had the clarification.
No, we haven't got...
Right, so what did it say? What was your request for clarification?
I think the request was, it pointed out that he hadn't mentioned in his judgment her evidence at all.
Right.
What did he...
Well, did it, for example, say to any... I mean, the purpose of clarification documents is to try and help the judge,
Yes, oh,
help
absolutely.
the parties,
Yes,
and simply saying to the judge, you didn't mention this witness,
yes.
might very well get a reply like this. If your point to the judge had been, this is to remind you, Judge, that it's incumbent upon you to give an assessment of the truthfulness of all of the witnesses that we called and explain why you don't believe them, then you might get a different answer.
Well, Lord, we would have assumed that he would have realised that he'd just made a mistake and not dealt with it properly.
Right.
So what he says in the clarification judgment, if that's what it is, order, core bundle 112 at the foot at the bottom.
That's the document, yes.
Yeah. Is, I accept I didn't refer to the evidence of the maternal aunt in the analysis. I confirmed I had a detailed note of her oral evidence before yesterday's hearing. I considered her written evidence. The mere fact I didn't include her evidence in my final analysis doesn't alter the findings I have made. So you say, what, that's...
He hasn't evaluated her at all.
Right, so that you say is an error.
Well, in our submission, it's a very significant error.
See, normally the court, certainly in other civil cases, the court can say that the mere fact that a judge doesn't mention a particular piece of evidence doesn't mean that the judge didn't have it in mind or evaluate it in reaching an overall factual conclusion.
What his function is to evaluate the lay evidence, and that means that he has to, in my submission, it's absolutely incumbent on him to evaluate all of the witnesses. The evidence of one witness.
But is that because? See,
I was just about.
Is it because you say that, in effect, what the judge has done is, without saying so explicitly, to find that all the people in the room that gave evidence were lying about what happened?
Yes.
Right, but as a general proposition, the mere fact the judge doesn't refer to every piece of evidence.
No. But here we've got 6 interveners, all faced with the possibility of included in a pool of possible perpetrators, and he has to examine what each one of those interveners says. I mean, it's possible that the evidence of
we don't have to complicate this. The point is, you shouldn't be put in the pool of perpetrators without your evidence being assessed.
Yes.
Right.
But it goes beyond that. It goes beyond that, because it's possible that one of the witnesses to the incident may be so compellingly honest or so compellingly dishonest that it provides key information in respect of all of them.
Now, for completeness, so that we've covered this fully thoroughly, you had a very large number of grounds of appeal, page 108 of the core bundle, paragraph 46 of the lengthy appeal judgment transcript. The judge also refers to this issue. It was your ground 14E, failure to consider the evidence of SH. Paragraph 46, page 108. Same.
Sorry, could you repeat that?
Yes. The judge also refers to this in the transcript of judgment refusing you permission to appeal.
Yes.
Paragraph 46.
Yes, thank you. I'll now move on to the other aspect, having dealt with the evaluation.
Fine. How long is this?
This is much shorter.
Right.
It's the failure of the judge to take into account the improbability of inflicted injury from the lay evidence. There are 3 aspects of this. One is improbability of inflicted injury due to the character of the relevant family members. Secondly, improbability of inflicted injury due to the circumstances existing at the time when the causative event must have occurred. And improbability of inflicted injury due to several features of the family evidence, which is, in our submission, impossible to reconcile with anything other than true accounts. First of all, as to improbability of inflicted injury deriving from the family member's character. The judge accepts their good character in paragraphs 180 to 181, but it is unclear how and to what extent he took this factor into account. All the judge says at 181 in the last sentence is, those are features of this case which are clearly in their favour. Has he taken it into account so far as improbabilities that people with their record across the board are unlikely, without more, to have committed this type of inflicted injury, an episode of shaking, or indeed perjured themselves in the way that the local authority was suggesting. So that's the first aspect of improbability.
Well, all of your submissions go not just to inflicted injury, but also to perjury.
Sorry?
They all go to inflicted injury and perjury, don't they?
And
Perjury.
And perjury, yes, absolutely, yes. The second point is that the position is much clearer in respect of improbability of inflicted injury deriving from the circumstances. There are perhaps three things to consider in this respect. What was the improbability of injury deriving from the circumstances? Secondly, how did the judge assess that improbability, if at all? And thirdly, did the judge approach any improbability in the proper way? What was the improbability? Well, there were two scenarios that the local authority mentioned. The first scenario, or in respect of both scenarios, one does have to take into account the very limited time on any view that there was for the causative event to have occurred. It was common ground, of course, that the causative event occurred after the video of the child happy and well at 9:47 p.m. And shortly before the 999 call was made at 10:24. So one's talking about the causative event must have taken place on the agreed evidence between 9:50 p.m. and 10:20 p.m. in that half an hour. And that's at its widest. The first scenario is that the shaking took place in the lounge with everyone present. This was the point that the one scenario that the local authority commented on, but thought that the judge would struggle with this and obviously didn't think that it was very likely. So the local authority then suggested a second scenario, namely that because the child started to play up, there's no evidence of any of this, because the judge started to play up, became a nuisance, one family member took the child out of the lounge to some other part of the house and inflicted the injuries in that other part of the house before bringing the child back to where the other people were gathered. That was the second scenario. The second scenario in our submission is as unlikely as the first. It is unlikely that the child would have been taken upstairs because two other children were sleeping up there. Downstairs there was only a bathroom and a kitchen which can be seen into from the lounge.
All right, well, can we, for our purposes, advance on the basis that you had a credible submission that there was a very high degree of improbability?
Yes.
Because of the extremely unusual identity of time, place, and presences
Yes.
there,
Yes.
which made this a very unusual case.
Yes. So we need to go to the skeleton. Right. Where's my skeleton? Right. And to page 9, where in paragraph 13, little g, we set out in G, little 1, what the judge said in respect of the first scenario. He said it at page 204 in his judgment, at CB 98. So at the bottom of page 9, I've put it out, set it out in the skeleton. Mr. Newton suggested I consider the improbability of such an event taking place in front of a lounge of family members and children. It would be inconceivable. I agree that such an event seems highly improbable, but as stated already, it is not the court's task to determine how Marwa's injuries were sustained. The task is to determine whether the local authority has proved its case on threshold on a balance of probability. What he says there. Then in little 2,
Would you say is he right or wrong?
he's wrong. But there's
Why is he?
well, he goes on to say something more about this in the next sub-paragraph, and my comment would really follow both. He goes on in paragraphs 47 and 48 of the clarification transcript at CB 109. He expands on what he said earlier and what I've already said. In paragraph 47, he says it would be useful at this stage just to remind ourselves of the legal document that Miss Jenkins provided to us, and it's page 6 of the bundle of authorities. It's an extract from the House of Lords in Re B, where Baroness Hale says this: in the context of care proceedings, this point applies with particular force to the identification of the perpetrator. It may be unlikely that any person looking after a baby would take him by the wrist and swimming against the wall, causing multiple fractures and other injuries. But once the evidence is clear that that is indeed what has happened to the child, it ceases to be improbable. Someone looking after the child at the relevant time must have done it. The inherent improbability of the event has no relevance to deciding who that was. And this is the important point. The simple balance of probability test should be applied. And then he goes on in 48.
Well,
so what does this mean?
Before we leave that, you say they're just begging the question. That's just begging the question that he had to answer.
Yeah, yes. He didn't take into account the improbabilities before he applied the balance of probability test. That's what his comments.
Yes, I mean there are some cases where sadly one sees that a child has got an injury which could only have been caused by abuse.
That's not this case.
No, so that's begging the question. And similarly, where the judge says at an earlier stage in a passing comment, fact-finding hearings are sometimes referred to as whodunits, that again begs the question.
Yes. That's the point. I mean, and it goes on. He then considers the second scenario in the paragraph that follows, he addresses it. So I make reference to the dispute, makes the point that I failed to take into account the improbability of a family member leaving the sitting room to take the baby who was behaving in an annoying manner elsewhere and had to calm them down. I do not speculate on that point, but what I can deal with is whether the local authority have proved their case on the balance of probabilities and nothing else. He hasn't taken into account, he hasn't sought to evaluate what the improbabilities from the lay evidence were of inflicted injury before he carries out his balance of probability study.
It is, in fact, the error the judge made in paragraph 47 when he refers to what Baroness Hale says, which is a case where it is obvious that someone has injured the child, you've got multiple fractures, and then conflated that with this case where you're actually deciding whether or not there has been infliction.
Precisely, my lord, precisely. And basically that's what is the effect of Re D which follows. And Lord Justice Baker's comments there are precisely what I submit applies in this particular case to the judges, and he has therefore failed properly to conduct that part of his exercise. He hasn't taken into account the improbabilities of inflicted injury from the lay evidence.
Right, so instead of treating it as if it would be speculating, the judge ought to have recognised that it was the core judicial task.
Yes, absolutely.
Not speculation. Right, well, we have that point.
Yes, right, yes. And the other aspect of improbability, which he didn't advert to at all, despite it being asked for clarification, is as set out on page 11, in paragraph H of our skeleton, that he failed to take into account several factors of the relevant family members' accounts that make it extremely unlikely that those accounts are fabricated. Well, I've set those out there, and I don't want to spend any more time on that. So those are the aspects of improbability which we submit he did not take properly into account. Those are my submissions in respect of ground 1. Ground 3 was created when the medical evidence was still in play, before your Lordship's decision that we couldn't rely on the medical evidence. And really, it applies more if there were both to be considered. But the point which does apply just as much to his to the what we've just been discussing, his evaluation of the witnesses, of the lay evidence, it does apply also, really. The same point that I've just made on improbability. He failed to take the improbabilities on the lay evidence. He applied the wrong test. He didn't apply the test properly.
Well, can we, for our practical purposes, focus on ground 1 only?
Yes. Yes.
I mean,
yes.
you've broken ground 1 down.
Yes.
In a number of ways.
Yes.
A to F in the grounds of appeal, but that's the menu.
Before I sit down, I would just make one comment about the respondent's skeleton, where it seems to be a theme running through the respondent's skeleton, that this was a case where the medical evidence was diagnostic. And I want to make it quite clear that from our point of view, and indeed our understanding of what your Lordship said when granting permission, that is not right in this case.
Well, it also, a reading of the transcript shows that, unfortunately, on a number of occasions, and I don't say this in a critical sense because one sees how these things go, that lay witnesses were being asked by counsel for the local authority, not counsel appearing today, for their explanations for the injuries, bearing in mind that the medical evidence showed that it must have happened as a result of an abusive episode.
Yes.
And the distinction between must
And
probably did
yeah.
was not always observed.
Indeed, no, yes. Well, those are my submissions.
Anything else, Jane? Thank you, Mr. Newton. Yes, now, Mr. Bennett, we'll rise at 5 to 1 if that's convenient, but you approach it in the way you like. If you want to give us an overview in 10 minutes, or just simply get on with it, as it were. Up to you.
Lord, obviously, I know you will have seen the skeleton argument, and reference has just been made to it. We've now had the transcripts, although I think you probably know that Mr. Newton and Miss Hunt kindly shared Miss Hunt's notes of evidence, so I can't pretend that I was taken by surprise. That was really...
Well, I didn't know that, but thank you.
Yes. I asked for the two authorities to be put in the bundle on difficulties in overturning or appealing fact-finding judgments. I don't need to address my Lord.
All right, well, remind, because sometimes these bundles, when they're in various different forms, evolve. Which authorities are you referring to?
They are...
Re-S and Re-T, are they?
Yes.
And why don't you refer to, no criticism, but why don't you refer to Volpe and the other jurisdictions?
They're referred to within those judgments.
Right, so it's because they're picked up elsewhere.
Yes, and I think my Lord Snowden made a reference to some principles from civil law that I know my Lords will be particularly familiar with, but they are featured within those judgments, even though they are from a civil jurisdiction as applying to the family jurisdiction.
Yeah.
And obviously, I mean, I know it's a pretty trite point, but I know my Lord will also have that in mind when considering the appeal points. The local authority's overall position is to contend that the judge was correct in his analysis of the medical evidence, and of course my Lord made a decision that that isn't to be susceptible of appeal. I do say that the medical evidence is crucially important, because of course it forms the vital base against which all evidence has to be considered. My Lords will recall that in...
Sorry, could you repeat that?
Yes, the medical evidence is crucial because it forms a basis against which all evidence has to then
I think you said it forms the vital basis, did you?
I say it's vital because it forms a basis, an important basis against which the other evidence has to be considered.
Well, we could spend some time on that as a concept. there's nothing, I think, that tells us that medical evidence has that special quality. It's evidence in the case along with everything else.
Yes, now I'm not asserting that it's of greater significance. There are many authorities where precisely the opposite is said, and the court.
I mean, the way it happens, I think. I mean, you were not trial counsel.
No.
But so with the advantage of perspective, the medical evidence lasted for days and days and days in this case.
Yes.
And it was called first, no doubt, because that's the easiest way to manage a trial with busy professionals.
And it most usually happens that way.
And it most usually happens that way. Yes. But it's not in a sense, it's not in some ways the logical way of approaching the evidence, where you have a number of given facts about the family, and you have then the family's evidence about what happened before any medical professional came anywhere near the child. But there we are. So what we have is a judgment which is in very great part concerned with the medical evidence, and at the end with an assessment of the lay evidence.
Yes.
And that's what's arrived.
But I think the point I wish to make is that I am seeking to make the point that Mr. Newton has anticipated, which is that although, of course, all of the doctors, the key doctors, accepted that it was possible that these very serious injuries, and I don't need to go into the detail, but the multifocal bilateral retinal hemorrhages, the bleeding in different parts of the and around the brain, and the posterior fossa, and the ligamentous injury, yeah. Those, my lord will know, are, well, first of all, quite unusual injuries, but secondly, the combination, the doctor said, was one which couldn't in any way really be easily explained by a fall. Each doctor said the usual thing they always say in evidence, my lord will know. They say, well, I can't ever rule out it being a possibility, because in medicine we don't rule out things like that. But you will recall passages, perhaps of Dr. Williams' evidence, where he started talking about it being part of really what would be a fringe theory or a freak occurrence. And then Professor Lloyd, my lord will have picked up, I think, that the first expert in relation to the eyes unfortunately became unwell. And so the parties went back to Professor Lloyd to give evidence, and he reported and gave evidence in relation to the eyes. And I think, if I've understood it, he gave evidence at a later stage than the other doctors, yes. So although Mr. Newton asserts, and I to some extent accept that these injuries were not diagnostic, they were nevertheless on the basis of the medical evidence, allowing for a theoretical possibility of accidental cause, but not really a real one. And so...
Not what?
Not a real one, not a real possibility.
But look, I mean, we're cutting to the chase here. Toddlers fall over all the time.
Yes.
There will be millions of toddler falls in the population every year.
Yes.
And it's true that the hospitals are not full of toddlers with head injuries. And it's true, clearly, in this case, that if the medical evidence was the only evidence, then it's extremely probable that this was caused by shaking. But nevertheless, ordinary statistical understanding, let alone expert opinion, has to allow for the fact that there are freak occurrences. And so the question is whether, because there are freak occurrences, and you know that there will be some, whether this is a pre-toddler who was that freak occurrence. And I mean, that's the issue the judge had to deal with.
It is, but there was no medical evidence in support of that in reality. So the judge had no medical evidence to support that this fall, as described, a simple fall. All the family members you have picked up said, look, it was something and nothing. We didn't really think anything of it. And indeed, when we come to look at their evidence, if we do, that may explain why, you know, quite a lot of them didn't pay a lot of attention to what was going on, which I accept is a part of everyday life. But there wasn't any medical evidence to suggest, really, in my submission, that this was a fall that could have caused these serious injuries.
Weren't there 3 examples given by the doctor of toddlers where it was unusual symptoms from these matters?
Yes, I mean, I have to say, perhaps you'll understand, I haven't focused in absolute massive detail on the medical because, of course, it wasn't in theory big before you. But I mean, I've drawn it up to your attention, so I do it. There were and there are examples, and that's why I think, first of all, they can't say never. But my recollection was that there was nothing similar to this. You know, there's a simple fall from a very low height.
When the judge was looking at this, I mean, we get more from the later judgment than we do the first, but in his paragraphs 47 and 48, when he actually confronts this issue, he takes what Baroness Hale says, which is, if someone has whacked a child into the wall and you've got fractures, well, assuming you've excluded brittle bone disease and all the rest of it, then it's not a question of, possible but unlikely. It is only non-accidental. And then the judge conflates that without, by then just saying, well, once you've got non-accidental, that's that. Whereas to decide whether it's non-accidental, you do have to go through the process of fairly evaluating the family's evidence. I mean, it might not have convinced him, but they're at least entitled to a reasoned rebuttal of it.
Lord, I say that's precisely what he did do. He formulated his, what he called, I think, provisional conclusions, or he said something like the medical evidence leads me to points to these conclusions, sets them out, and then goes on to say precisely what my lord says. I then need to overlay the lay evidence.
Thank you.
I mean, we do have in a very helpful and condensed form the judge's conclusion about the medical evidence at paragraph 178, which is on and I mean, I know that in your submission you're, as it were, seeking to say that the door was really closed against a non-accidental conclusion.
An accident, yes.
An accidental conclusion, yes. But that's not really, that wasn't the judge's finding. I mean, he...
Well, I mean, those are the paragraphs that I was referring to when I said that the judge set out his, whatever he wants to call it, points to the following conclusions, which he then applied the lay evidence to thereafter.
I mean, there were a number of features which individually and collectively pointed very strongly towards this being a shaken child.
Yes.
And I mean, the local authority had no other evidence. There was some detour in relation to the history of the eldest daughter, which was really very unprofitable.
Yes.
But I mean, the case that you'll have to meet after lunch is fair enough that all of that could properly persuade a court that even the most impeccable family has shaken a child and covered it up. But that simply the judge didn't reason his way to that conclusion with anything like enough, either rigour of analysis or fairness to the individual family members who are entitled to know, in broad terms, what evidence wasn't accepted and why. And I think that's what we're wrestling with here.
I understand.
And also, I mean, again, without preempting in any sense where this all leads, that to the extent to which you could help us with what next, if indeed the appeal succeeded in deleting the findings, would be a matter which, in this peculiar circumstance of this case, where everything seems to have run ahead of the appeal, might need some careful thought.
Oh, yes.
All right. So let's start again at 2 o'clock. Thank you.
Right.